Hello, everybody. Welcome to our YouTube channel. My name is Remzi Kulen. I'm an immigration lawyer. And today I have a wonderful colleague of mine. Her name is Vanessa Vasquez de Lara. We actually met at a networking group. She's a great divorce attorney in Florida. And we started talking about immigration and divorce and family law and realized that there's a lot of things that we can discuss in a YouTube video because a lot of issues come up during the marriages, separation, divorce, marriage, prenups, and how does that interplay with the immigration applications is a very hot topic, and we get questions all the time. And she told me that she gets questions all the time. So we thought, why don't we do something together? Hi, Vanessa. How are you?
Hey, Remzi, how are you?
Thank you. I'm in New York. It is very cold today, around 30 degrees. So I don't want to ask you how the temperature is in Florida, but why don't you tell us?
It is a balmy 80 or 85 degrees down here in Florida, so it's very nice. You should come down.
Okay. Yes, I'm jealous already. I will make the arrangements. Thank you. So can you talk a little bit about yourself and your practice?
Absolutely. So, my firm is the Vasquez Lara Law Group, and we are a family law only law firm down here in South Florida. We only handle family cases. That's going to be your divorce, your custody, child support, prenups, and postnups. So, anything that has to do with putting together or taking apart a family, that is what we do.
Well, great. A little bit about us. We are an immigration law firm located in New York. Immigration law is a federal practice. We do almost everything in immigration except for removal and asylum. So we do a lot of family cases, we do a lot of business cases, and questions do come up when a couple is getting married or separated or divorced as to how this will affect the immigration application. So I think we can discuss about some of the things come into our attention. And I will ask you your opinion about the family law aspect of it, and then I will maybe explain the immigration part of it. So we had some talking points while preparing for this, and I want to start by asking you, what are some of the considerations when a couple would like to get married? I know you are a family lawyer. You know, they usually come to you during divorce, but they also come to you before getting married, right? So
Absolutely.
what are some of the considerations?
The biggest thing that a couple wants to consider, especially when there's any kind of immigration issue involved, is having a separation of their assets and their debts. This is actually something that is common in other countries where you are getting married under a separation of assets and debts. But that is not a thing, at least not here in Florida. And in most states in the US, that's not an automatic thing that you get to choose when you're getting married. But you can contract for it. So what we always recommend, we never want to wonder whether somebody's getting married for papers. We never want to wonder about our partner and what their intentions are. So by having a good prenuptial agreement, you don't have to wonder because you're already making sure that you're protecting yourself, that you're protecting your assets, that you're protecting your family by making sure that whatever you come into your marriage with, that is what you will walk away with should the marriage not work. And, we got some questions because of the affidavit of support that does require the US government does require that support for your spouse for a period of 10 years. But the reality is that the support that is required is really very minimal in comparison to what the law can sometimes give a partner when there is no prenuptial agreement. So you're basically the support is talking about making sure that the person doesn't collect government benefits. That floor is very low, and the amounts that would be paid to that partner would be very low, while an alimony claim, we've seen claims for thousands and even tens of thousands of dollars in alimony claims. So it's really a very good protection that citizen would have by making sure that they have a prenuptial agreement that talks about assets, debts, and potential support in the future.
Okay, that's an excellent point. Actually, prenup is somewhat, let's not talk about that in immigration procedures, because what immigration officers would like to see is commingling of funds, that they don't take anything away from each other, that they come to this marriage union. But now that I'm listening to you and understanding where you're coming from, actually, prenup may work in the immigration context too, because yes, they are signing an H-64 affidavit of support form, and they are saying that they're going to support their spouse. That doesn't mean that they want to give away half of what they have before the marriage took place. So I think there's a way that this can be strategized into the immigration strategy. But it's important to note that as of now, there's nothing in the immigration forms that asks whether there's a prenup or something. So it is not something that we usually voluntarily submit in the immigration applications.
Right.
But of course, if there is a question about whether there's a prenup, and in the 23 years that I'm doing this, I've never asked that question by an immigration officer.
Right.
But people should be truthful. If there's a prenup, they should tell the office that there's a prenup. And a prenup doesn't prevent you from filing an immigration application for your spouse. I think that's the most important.
Definitely not. And what people don't realize is that prenups are good for all couples, not even, not just immigration couples, because it allows you to have those conversations that don't naturally come up. It allows you to talk about are you a spender? Are you a saver? We've seen and we've drafted prenuptial agreements where it specifies we will have an account, a joint account. That account is going to be used in this way. Our rent will be paid this way. Our mortgage will be paid this way. Our bills will be paid this way. We will contribute in this manner to this account. So it really allows the parties to get on the same page financially, which is something that, especially if you're coming from a different cultural background, that's a conversation that not a lot of couples will often have just naturally. So having that agreement in place and making sure that you're having those conversations can actually lead to a stronger marriage, a better, more planned marriage, which, as somebody who believes in marriage, I think that that's really a win-win proposition.
It is true. I mean, I think this is the importance of talking to a professional who's doing other type of legal work, because most of the time when you get married and when you have a prenup, it is, symbolized or described as something very premeditated or not having the good intentions. You know what I mean? It's almost like you're going to think about marriage is going to fail and you're taking precautions. It's not that. But exactly like you said, having these discussions early on would also make the marriage stronger, and maybe even the immigration case stronger, because then they would have answers to the questions that the officer can ask, and at the same time they would be financially prepared if something bad happens. If something good happens, everything is good anyway, but if something bad happens, we usually are not prepared for it. So that's a very good point. Do you do a lot of prenups? I mean, is it very common these days?
It is. It's one of those things that when I first started practicing over 20 years ago, prenups were just not as widely accepted. And, you kind of heard about them, rich people, maybe Hollywood stars, but it is something that now there's so many people are waiting so long to get married that they usually have assets. They might have a retirement account at work. They might have a property. If it's a second marriage, they may have received assets from that first marriage. So we do see them a lot more frequently now than we did when I started practicing.
So this is probably a nice segue to the U.S. citizen spouses or the immigrant spouses' contribution to alimony or child support if there is a divorce. So how does the prenup interplay with this kind of responsibility? Because there is an immigration aspect of it, and I'm going to talk about that. But if you have a prenup, does that change anything with respect to alimony or child support?
It absolutely can. So prenuptial agreements will only deal with very specific financial issues. And that's going to be your distribution of assets and debts, your potential alimony exposure or payments. And in Florida, at least, we also deal with inheritance issues because Florida law does not allow you to disinherit your spouse while you're married unless there's a valid prenuptial or postnuptial agreement. Not every state is the same, so it's always a good idea to know that. But in Florida, you can't disinherit your spouse without this agreement. So it's something that is really important, and we make sure that we address in our prenups. You cannot deal with anything related to children. All issues related to children, the court is always going to have the best interest of the children in mind. So child support, time sharing, those types of issues cannot be contracted and cannot be included automatically in a prenup. will sometimes include some language that the parties believe that, that both parties are going to be great parents and that that they should have equal time sharing, things that the law sort of allows for. But those are going to be basically flowery language. It's not going to be something that is binding on the court. What is going to be binding on the court is going to be anything related to financials. So alimony, inheritance, and assets and debts, those are going to be the things that that contract is really going to put into play and is going to, require for purposes of enforcement. This is especially important in a family where there's an immigrant and a non-immigrant, because all the calculations are done based on income. And if the immigrant spouse is actually making more than the non-immigrant spouse, well, guess what? That potentially allows for that U.S. citizen spouse to actually collect alimony from the immigrant unless there's a prenuptial agreement. So it really does benefit both ways. We do see a lot of, highly talented immigrants, executives, and things like that coming into the U.S. So it's not necessarily that they're in a lower financial position. Sometimes we see them in a higher financial position. And so this really allows them to be on the same page and ensure that, that they're coming in with an understanding of what they're both contributing into the marriage and what they're both bringing to the table. But it allows to make sure, sort of like that phrase of trust, but verify it. Trust, but make sure that you have an agreement as to what happens if things go south. You always want to make those agreements when everybody's getting along, when everybody's happy and in love, where everybody's thinking about the best of the other side, and just having that kind of like as a protection in case things don't work out, in case things don't go well, or in case anything happens that, kind of upsets that proverbial apple cart.
So basically, there are things that you can put in a prenup, and there are things that you cannot put in a prenup. And child support comes to mind,
Yes.
and it has a very interesting aspect of it in immigration law too. We recently had a case, and this was in Florida. This was a single mom filing for naturalization, and we're going to come to that. But they were divorced for a long time, and the child was in the custody of the father. We still got an RFE, request for evidence, asking for child support from the immigrant spouse.
Yeah.
And according to the separation, according to the divorce agreement, she didn't need to provide anything. It was only the father who took that responsibility. But again, USCIS asked for it, and they said, even if it's not in the divorce settlement, the spouse who's not having the child still needs to provide child support to the child. We need to see it because we take a look at it and we see it as a good moral and character. So luckily, obviously, this client was taking care of her child, sending school payments, tuition payments, and living expenses. So we were able to prove it, and the case got approved. But it was a very interesting example of how USCIS is actually trying to figure out if the immigrant spouse is providing child support and considering that a good moral and character for naturalization application. It was an interesting case.
Yeah, I mean, in Florida, at least, child support is the right of the child. So although it is paid to a parent, it's actually the right of the child. So it's something that we are not legally allowed to waive it. There has to be an understanding in that final judgment or in that support order that talks about how each parent is contributing. Yes, we do have situations where the parents have equal time sharing, equal overnights. They make equal amounts where, obviously at that point in time, they're equally responsible for that child, and there really isn't a payment back and forth. But whenever you don't have that type of equality, you really do have to demonstrate why there's not a payment, because our charts are designed to make sure that that child is being supported by both parents.
Exactly. And it is also important to note, as you said, that because family law and divorce is regulated by state, each state may have different rules about this. They may have a different rule about prenup. They may have a different rule about marriage and divorce proceedings. They may have a different rule about child support. So yes, immigration law is federal law. We can help clients from all over the nation. However, when it comes to family law, we need to find out what the state's laws are. So if you have a friend who got divorced in New York and is involved in some kind of procedures, that doesn't mean it's going to be the same in Florida, because Florida may have different laws. And I think
100%.
you see this all the time, right? Is it possible? Is it appropriate to say that family law differs from state to state significantly, or maybe in some aspects? How do you have any idea about that?
So, I mean, there's community property states, which are going to be different than equitable distribution states. There's going to be rules, like I believe New York has child support until 21, while Florida has it until 18 or until high school graduation. So there's definitely going to be differences. We have actually been seeing a lot of New Yorkers who are moving to Florida and have to enforce their agreements, or may need some type of modification of the schedule, or may need to try to do, certain things. Some things can be changed after the fact. If there's a final judgment in New York, there are some things that can be enforced or modified if that parent moves to Florida. There's other things that can't. Once you've established child support in a different state, you can't then say, well, let me choose which state has better child support laws and move there so that I can get, a different child support award. You're kind of stuck with that child support determination from your original state. So that's something to consider. But we have done collections and enforcement actions in clients. I'm, particularly thinking of one from New York, where they have a decree that ordered a child support where, that second parent was not making those payments. We knew that there were assets in Florida, and so we domesticated that final judgment, and we filed a contempt here in Florida, and we were able to get that parent that needed that support out of the assets that other parent owned in Florida. So it's definitely something that you have to be aware of, where your final judgment is at, but there may be enforcement actions that could be done wherever the other parent has, especially if they move to a different state after the divorce or after the original final judgment is completed.
I think it is important to note that you need to have a divorce attorney, and you need to have an immigration attorney for these proceedings. Sometimes you see attorneys say they handle both. I mean, if you're handling both, you probably don't know everything very good at all. So I always tell my clients, avoid mixing of different specialties.
Right.
You go to an eye doctor, and you go to a pediatrician for something else. You don't ask the same doctor all of your problems. So it's about the same thing in the law. You have to have a good immigration lawyer. You have to have a good divorce lawyer, and then they talk to each other and they solve problems. But
Exactly.
if you give all the specialty to one person, that person is probably not going to know everything, which is a huge problem. Huge problem.
We definitely encourage that. Whenever we get any of our clients or potential clients who have an immigration issue and a family issue, we always encourage that they talk to the immigration attorney first, because the divorce ultimately can be delayed. The divorce can be done without litigation. There's a lot of agreements that could be done in the divorce. But if you mess up the immigration, there's really no good way of fixing that. There's a lot of ways of fixing a final judgment or a divorce, or, kind of kicking the can down the road. But that's not always possible in an immigration case. There's a lot of things that are very time sensitive in immigration that really need that attention first. So we will always recommend, if they come to us and they say, well, my immigration attorney said X, I'm like, you need to make sure that you talk to them, that you let me talk to them, so that we can be on the same page about what it is that you need, so that we can make sure that we are getting you in family court exactly what you need. As I was telling you earlier, we literally had somebody call us today who talked about that they and their ex got divorced in another country, that allowed them to get that divorce without being in that other country. That's a legitimate divorce for most purposes.
Mm-hmm.
But as you can tell us, it's not a legitimate divorce for immigration purposes, because neither party was in that country when they got that divorce. And we had to basically tell this potential client, I'm so sorry, but if you are trying to bring in a new partner, you're going to have to get divorced again from your first partner and get remarried again to your second partner before you can start that immigration process to bring in that second partner.
That is exactly true. I mean, It gets really complicated when the marriage took place in another country, and then divorce took place here, or vice versa. So you definitely need to know now also the laws of that country, and maybe get a foreign lawyer involved in this to figure out what is the exact way of doing this. What you shouldn't do is definitely don't do anything on your own thinking that this might be the right path,
Right.
because especially with immigration, some things cannot be undone. If
Yes.
you're already in a polygamy, that's a permanent bar to immigration law, to immigration benefits.
Yes.
So always seek the guidance in advance. This is actually a nice segue to another problem that we face all the time in family cases, is that the couple gets married, they're in love with each other, they file the application, we get the case approved, and now they have a 2-year conditional resident card. And the premise is that you need to apply for removing the conditions of residence in the last 90 days of that 2-year period, and then you get a 10-year green card.
Right.
Now, it gets problematic when, or a little bit more difficult when the marriage fails within that 2 years. So you have the conditional card, you don't have the 10-year card yet, so you're going to file a new application, and that application needs to be filed with your spouse if you're still married, but the marriage fails. Have you seen any instances like this? People come to you about this?
We definitely have. And, and that's again, Ramsey, where we bring in their immigration attorney to figure out, okay, well, listen, in a divorce, most things are negotiable. So, it may be something where we need to negotiate. Listen, we need you to agree to allow these conditions to be removed, and maybe let's delay the divorce until the conditions are done. Otherwise, sometimes, when we see that there may be issues of abuse or issues where any kind of coercive control, where the citizen spouse is sort of not allowing the immigrant spouse to have the freedom to be able to do certain things. Sometimes we have to talk to the immigration attorney about, listen, this is the citizen spouse isn't agreeing to certain ideas, or isn't agreeing to delay, or isn't agreeing to cooperate. What are some of our options, knowing what has happened inside of that relationship, whether there's been abuse or whether there's been any kind of any negative financial situation, or having to deal with potential domestic violence, because that we do see quite a bit.
Well, if the domestic violence took place before the case was filed, the green card case was filed, then there is Violence Against Women Act, VAWA, which protects vulnerable spouses from being abused. So you shouldn't be putting up with abuse by the threat of not getting a green card. There are mechanisms to prevent that, and VAWA is before you get the green card. You can file on your own, prove the abuse, and still get the green card. We do cases like that all the time. In a situation where the green card application is approved, you have the 2-year conditional resident card, and then you're facing some kind of a failure in the marriage. Most people think that they still have to stay within the marriage, even though they cannot get along or they are facing abuse, because they think that they must file the removing the conditions of the applications with their spouse. This is not true. This is not true. This is a very important message, that if you're not getting along, if you don't want to stay in the marriage, you can get a divorce within that 2-year period, and you can file on your own as a divorced person. Now, what you need to prove, though, is you entered into the marriage in good faith. So when you were getting married, you were in good faith, but the marriage didn't work out in the next 2 years or so. This is perfectly okay. We do cases like this all the time. It's a little scary for the immigrant spouse because sometimes they get threatened, like you said, by the U.S. citizen spouse, or sometimes there is abuse, but the U.S. citizen spouse is not with good faith, and they're actually using this green card against their spouse. And in all of these instances, it is very important to talk to the immigration lawyer first. I agree with you.
Always.
Because eventually we're going to send the client to the divorce attorney to handle the divorce part of it. But we must first need to understand where they stand, what kind of documents they have, what can be done for the application. And it is very interesting. I don't know if you know this, but when you file the 751 application, removing the conditions applications with USCIS, you either have to be married or divorced. So immigration doesn't recognize separation as one of the filing conditions.
Right.
Did you know this? Maybe you
I did
knew.
not, but
Yes, yes.
in Florida, we
So-
don't have separation. So that's, that's good to know.
Yes. So what happens is, let's say you're towards the end of the 2-year conditional resident card, you cannot get along and you want to file a divorce, you don't want to stay in the marriage. We still file the case, but we indicate in the application that the divorce proceeding has been going on. And please, USCIS, send us an RFE, request for evidence, to ask for the divorce document. Or if you're going to give us an interview, then we will come there and show you the final divorce proceedings. But a 751 will no way be approved unless there is a divorce decree. So there's a lot of strategy that goes with it. Timing of the filing,
Right.
what are you going to say in the application? How are you going to fill out the forms? So there's a lot of stuff that needs to be figured out. That's one of the difficult parts of the 751 practice. But again, that shouldn't be a reason for you to stay in a marriage that you're not happy.
So Ramsey, something that we do see sometimes is our clients coming in and either considering a divorce or maybe have already gotten divorced and we maybe handled their divorce, but they're now considering what they need to do to, to make sure that they get their citizenship, because especially in our climate, we want to make sure that we are full, bred US citizens. So what do you typically recommend to those clients about waiting or about what they need to be thinking of when they're thinking about that next step for citizenship?
So if you got the green card through a marriage to a US citizen and you were living together with them and still married, then you can file for naturalization 3 years after having your green card. This is an advantage for US citizen spouses.
Okay.
However, if you are not married or if you're not living together, these are two separate things. People confuse this all the time. I'm still married, so I can file after 3 years. Well, are you living together? No. Then you cannot file after 3 years. You have to be married and living together. Then you can file after 3 years. If you got a divorce at some point, then you need to wait for 5 years from getting the green card. And this is important because most of the time people want to get the instant gratification. We just want to file at the 3rd year mark. We want to get the green card. You will be asked questions as to whether you're still married and you're still living together, and you have to show proof that you're living together. So it is important that if you're not living together, if you're not, even if you're not divorced, if you're not living together, don't file it before the end of the 5th year mark. Because if you wait, your application will be easier, it will be smoother. You won't be asked to provide documentation as to whether you're living together with your spouse. It will not come to probably the question of whether the marriage was real. I mean, don't forget, in every immigration application, the previous application can be questioned again. It's always the same alien file. Everything is in that document, in that file, can be questioned again. In your second marriage, you're filing a green card, your first marriage can be questioned. In your naturalization application, how you got the green card can be questioned. So try to make it easy for everybody, for yourself and for the officers, I would say.
Definitely. Preparation is key, and making sure that that file is as perfect as possible. I agree. I always want to make sure that we are sending our clients to, to great immigration attorneys like yourself. So what are some of the things that we should be asking as family lawyers to our clients to make sure if we need to send them maybe things that are not obvious? Obviously, if they come in and say, well, I'm undocumented, or my husband got me my green card, that's kind of like a natural segue to send it to an immigration attorney first. But what are some questions that maybe we don't necessarily ask that we should be asking to make sure if we need to talk to, or if our clients need to talk to an immigration attorney before we start the process of the divorce?
I think what is important, I mean, there's a lot of important things, but for example, multiple marriages is always a question mark for immigration purposes. A huge age difference is always a problem for immigration purposes. Prior arrests, convictions. These are important. But probably the most important thing is documentation. Because in immigration proceedings, you go to the interview, the officer has 30 minutes to an hour to decide whether this marriage is real, whether it was entered in good faith. It is very difficult, and they don't have the resources to send people to their home, to your homes, to figure out if this is a real marriage. So documentation is key. I had a client for whom I filed a 751. This guy was in love with his wife, and the wife fell out of love and wanted to get a divorce. This guy actually burned everything they had together in a fire. All the letters, all the photos. I'm like, do you have anything that proves that you were in a good marriage together? And like, I burned everything. I was so upset. So I said, that's a mistake. Don't do that. So documentation is key. So sometimes people get upset. They want to destroy things. They shouldn't. We have to have some proof, some documentation that the marriage was real. And sometimes there's no documentation, that we go into affidavits. But these are some of the things that come into mind when advising to couples.
It feels like in the age of social media, with pictures, Facebook, Instagram, Snapchat, TikTok, it feels like we are constantly putting our lives on display. So I would, I guess, encourage our clients not to delete all of their ex's pictures and all of their things, especially when they potentially have an immigration case.
I think Vanessa, oversharing is a problem. At the same time, not taking photos of anything, not keeping receipts of anything is also a problem. Just we have to be somewhere in the middle. And especially if you're trying to prove that a marriage is real, I think stay on the safe side and keep everything together.
Makes sense.
Yes. Okay. I guess that's it. But this was a very nice conversation. I learned a lot of things. Some things that I thought were true were maybe not that true. I mean, this is great. I mean, this is why it is important that lawyers from different fields talk to each other, especially if they're touching elbows while doing their jobs. So I thank you so much, Vanessa. This was very informational for me.
Thanks, Remzi. I love talking about family law and how we help our clients and how we make their lives better in and out of family court. So I think that you're doing the same.
Yes, we also do have that in common, that I think we do help clients. And coming from an immigrant background myself, I went through all the difficulties in immigration processes. And it was not easy for me because I was an immigration lawyer. And now I can show this empathy to the clients, and I can understand how they feel when they get that request for evidence or when they get that interview notice. So we try to help people. I mean, otherwise, I don't think you can do this otherwise. If you don't like helping people, I wouldn't want to do it in a scenario where I have to do this, but helping clients or helping people don't give me any satisfaction. So I'm really privileged, I think, to be able to do this. My living out of this, yes, but at the same time, being able to help families, entrepreneurs get their status in the US. And you probably make people happy too when when they want to get...
Hi.
Well, eventually, right?
Eventually. Once you start that new chapter or that new book.
Yes, exactly. Okay. Thank you so much. Why don't we follow up with an Instagram Live? Maybe we can post it. We can post it beforehand. People can ask their questions, and then maybe we can go over the questions, or we can go over the similar stuff that I'm sure I'm going to have a lot of questions after this, thinking about this. Thank you so much, Vanessa, for making this, and hopefully we'll do it again.
Thank you, Remzi. Have a great one.
Thank you. You too. Bye. I hope you like this video. If you have any questions to me or to Vanessa, please put it in the comments section so that we can respond to it. If you think this was helpful, please like the video and subscribe to the channel and open the notifications so that you can have advanced information about the videos posted. I will see you in the next video. Take care.